Welcome to the Pro Bono Project YouTube presentation on record clearance basics. Today we'll talk about the basic general outline of record clearance and what is available to you. So what is expungement? Expungement, also called record clearance or dismissal, is a way to clear up your record by limiting the criminal history that is available to certain people performing background checks on you. It eliminates some of the consequences associated with the criminal conviction. And it's also called dismissal because the guilty plea is set aside and the court dismisses the case. The case is now shows on your rap sheet as cleared or dismissed. This does not erase the conviction from the rap sheet, but the expunged convictions do not show up on most private background checks, such as by jobs and housing. What are some of the benefits of expungement? As I noted, expunged convictions do not show up on most private background checks by private employers and landlords. Important exceptions are jobs with law enforcement or with children. An exception to the children exclusion is that certain drug convictions, which are more than 5 years old and were granted record clearance, are not disclosed. And also, any application for teacher credentialing shall not be denied solely on the basis of an expunged drug conviction. What are some of the limitations of expungement? Again, licensing boards and government agencies, they can still see the conviction on your rap sheet, but the expungement should reflect favorably on your case. If there are later criminal convictions or later criminal charges, it may still count as a prior conviction. It may still count as a strike. Expungement does not restore firearm rights. It also does not affect sex offender registry requirement or other registry requirements. It does not affect any criminal protective orders which are in place. And there may be others which are affect your particular case. What types of expungement are there? So this presentation only addresses expungement for California state court convictions. If your convictions were in another state or for federal court, those processes would necessarily be different and are not covered here. So there are two basic types of expungement, mandatory and discretionary, or also called in the interests of justice. California offers mandatory and discretionary record clearance for most convictions, including some prison felonies. So certain convictions, such as infractions, misdemeanors, and some prison felonies, can be cleared from your record if they are non-serious, non-violent, and non-sex registry offenses. If you are not eligible for mandatory record clearance, you can still petition the court for discretionary record clearance in the interests of justice. As of July 1st, 2024, many of the mandatory expungements will become automatic. However, this depends on Department of Justice funding for this program. So we are seeing some are being expunged automatically, but we still also recommend to folks that they go ahead and petition if they don't want to wait for the court. In all cases, you must have completed your sentence, including probation or supervision. An exception to this is if you've served in fire camp as a hand crew member or institutional firehouse. This is discussed later. You must not have any new charges pending. You must not be serving a sentence on another case, and you must not be on probation for another case. So there must be nothing going on right now in terms of the criminal justice system. No charges, no probation, you're not in custody, you're not serving any kind of sentence. So the first big bucket of mandatory/automatic record clearance. There are three classes under this of mandatory automatic record clearance. The first is for a felony conviction on or after January 1st, 2005, and this includes prison sentences. So 4 years have elapsed since you completed a sentence, and in that time you had no new felony convictions. You can have had misdemeanor convictions, but no new felony convictions. You are not currently on active supervised release. You have no pending charges. This excludes serious crimes, violent crimes, and certain offenses requiring Penal Code Section 290 registration. So, for example, if you had a felony conviction and on January 2nd, 2005, and you finished your sentence December 1st, 2007. As of December 1st, 2011, if you had no new felony convictions in that 4-year time frame, and you're not on active supervised release, it is no pending charges. It was also not a serious, violent, or a 290 registration requirement, then you would be eligible for mandatory record clearance for that conviction. Mandatory automatic record clearance also for the second area of felony convictions after January 1st, 1973. You received probation and it was completed without revocation. Again, you're not on active supervised release and you have no pending charges. This also excludes certain offenses requiring Penal Code Section 290 registration. The last big bucket of automatic mandatory record clearance is misdemeanor or infraction convictions after January 1st, 1973. If you completed probation, or if no probation was given to you as part of the sentence, 1 calendar year has elapsed. You are not on active supervised release. You have no pending charges. And again, this excludes certain offenses requiring Penal Code Section 290 registration. So with these areas of mandatory and automatic record clearance, as I mentioned before, they are supposed to be automatic now. However, that relies on Department of Justice funding to go through and update their database and change your rap sheet to reflect the clearance. So we are not sure in what order the DOJ is doing this. So we recommend to folks, and what the funding is. So we recommend to folks to go ahead and petition the court and not wait around for DOJ. So if you don't apply, you're not eligible for mandatory automatic record clearance, what other option do you have? And that is discretionary record clearance, which this applies when you're not eligible for mandatory record clearance. It addresses a situation where probation was violated or not successfully completed. It requires a court hearing to allow an explanation of why record clearance is in the best interest of justice. And then it is the judge's decision whether to clear your record or not. Some convictions, such as DUIs, are always discretionary. So even if you had met the other requirements for mandatory automatic, if it falls into that area of always discretionary. Another one that readily comes to mind is driving with a suspended license. That is always discretionary. So discretionary record clearance generally applies when you received probation and did not complete all of its conditions, or you did not receive probation and did not complete all the requirements of your sentence, and you had a negative contact with law enforcement within 1 year following the conviction. 1 year must have elapsed since your conviction, and you are not now charged with, under supervision for, or serving another sentence. So discretionary record clearance is applied to prison felonies. So again, if you were not eligible for the mandatory, any felony conviction, including prison time, is part of the sentence. So if it's a state prison sentence, you are eligible for discretionary record clearance in the interest of justice 2 years after you've completed your sentence. If it's a prison sentence served in county jail, so if it is a straight term, so all your time is served at county jail, 2 years after the completing the sentence, or if it is a split term, so half in county jail for a prison sentence and the other half outside, 1 year after completing your post-release supervision with no new conviction. This excludes certain offenses requiring Penal Code Section 290 registration. As with the others, you must not have any new charges pending, you must not be serving a sentence in another case, and you must have completed your sentence. Fines and fees, restitution orders that are unpaid, that will not hold up record clearance. And we'll talk more about that later. So some major takeaways of where we are so far. Generally speaking, mandatory record clearance for most misdemeanors and infractions with successful completion of probation. Or if you were not placed on probation, after 1 year, if no new legal issues. And this is automatic after July 1st, 2024. Also after July 1st, 2024, automatic record clearance for all non-serious, non-violent, non-registerable felony convictions after 4 years, if there have been no new felony convictions within the 4-year period after sentence completion. All felony convictions, except for certain Penal Code Section 290 offenses, registration offenses, are now subject to discretionary relief 2 years after completing the sentence of straight time, or 1 year after all post-release supervision is completed. And we didn't go over arrests, but automatic record clearance for all arrests that did not result in a conviction. There's a robust practice of arrest record sealing. So if you were arrested and not charged, or you were arrested and the charges were later dropped, or if you were detained only, you can petition the court to seal that arrest record. So all felony arrests that did not result in a conviction are clear within 7 years of the arrest, and misdemeanors are fewer. It depends on the basis of the possible length of the sentence if you are convicted. A short note about fines and fees. Again, owing fines and fees does not hold up record clearance, and outstanding victim restitution orders are no longer a bar to record clearance. So it does not matter if you owe fines and fees or if you owe a restitution order. That won't hold up your petition for record clearance. So some particular issues to talk about regarding felonies and expungement. So in some certain circumstances, you can petition the court to reduce your felony to a misdemeanor. And so some of these felonies can be reduced to misdemeanor. This can be done as part of a petition for record clearance or as a separate petition later or earlier. You can do it in whichever order you prefer. The advantages of reducing a felony to a misdemeanor: it looks less serious on your record. You can say you have not been convicted of a felony when you're asked, and it may restore certain rights lost with the felony conviction. Your felony can be reduced to a misdemeanor if your felony was a wobbler offense and you were sentenced to probation and or county jail. If you serve time for your felony in state prison, you are not eligible for it. A wobbler is an offense that can be charged as either a misdemeanor or a felony. And you can find out if your felony offense is a wobbler by looking at the penal code section of your conviction. And if it states the offense is punishable by either county jail or state prison, it is a wobbler. And again, you must have served the time in county jail, not in state prison. So a wobbler is eligible for reduction if it is an offense that is eligible for record clearance and you meet all the other requirements for record clearance. A few more things about wobblers. If the judge grants your petition to reduce a wobbler felony to a misdemeanor, some penalties do not go away. As with other things, it still counts as a strike. You must still comply with sex offender registration requirements, and some state licensing agencies may still consider it a felony in very narrow circumstances. Wobblers are not mandatory. They are discretionary in the interest of justice. Thus, it's in the court has discretion in deciding whether to reduce the felony offense to a misdemeanor. Judges can consider the nature and seriousness of your offense, the facts of the case, your behavior while on probation or under supervision, your prior criminal record, and any other factors in your case. One side note about fire camp has noted fire camp has a different process for record clearance. So Penal Code Section 1203.4b allows record clearance for certainly formerly incarcerated individuals who participated either in the CDCR fire camp or institutional firehouse program, or they served as a county incarcerated individual hand crew member. So if you served in any of these capacities, you are eligible to have the conviction for which you were serving expunged. You can apply for expungement immediately on your release from custody, even if you are on probation, parole, or post-release community supervision. Some important notes for fire camp expungement. For CDCR fire camp or county hand crew, you must have actually participated in fighting the fires. You can't have been the cook or a driver. You must not have been removed for any negative behavior. You must have completed the program in good standing. Certain classifications of underlying crimes are not eligible, and you must currently not be charged with the commission of another offense. So as we noted, you can be on probation for the offense for which you were serving while you were on the fire camp, but you must not be charged with the commission of another offense. So what if you're listening to this and you're saying, okay, mandatory doesn't apply to me, discretionary doesn't apply to me. Is there anything else I can do? So there is another option for that, and it's called a certificate of rehabilitation. So if you're not eligible for a mandatory discretionary record clearance, you can petition for a certificate of rehabilitation. This does not expunge your conviction, but it can help your chances when you're applying for a job, housing, certain professional licenses. This is a court order stating that the court considers you to be rehabilitated. This may eliminate a Penal Code Section 290 registration requirement. It may restore firearm rights. And also, if the certificate of rehabilitation is granted, it is an automatic application for a pardon from the governor. So you are eligible to apply for a COR in two different circumstances. The first, you were convicted of a felony, you served your sentence in California, and you completed your sentence and were released or released on parole, and you have lived in California for the last 5 years. The other way to be eligible for a certificate of rehabilitation, you were convicted of a felony or misdemeanor sex offense. The conviction was expunged under Penal Code Section 1203.4. You have not been convicted of another felony or incarcerated anywhere since the conviction was expunged. You are not on probation for any other felony, and you have lived in California for at least the last 5 years. There may be additional time required for this living requirement based on your conviction. So a certificate of rehabilitation will not erase a felony conviction, and it doesn't necessarily eliminate your registration requirement, and it does not allow you to say you were not convicted of a felony. It is also still considered a prior offense for any later offenses. Once you file your papers, the DA will investigate and prepare recommendations for the court on whether it should grant your certificate of rehabilitation. If you would like more information about record clearance basics, please reach out to our office. There's our contact information, and we look forward to hearing from you.